Before you upload a photo to Facebook, send a WhatsApp message, bought something online, or even created an email account today, did you ever stop to think about the laws behind those actions? What happens if someone hacks your account? Can a screenshot be used as evidence in court? Is downloading copyrighted content legal? Who owns the information you share online? Welcome to Law Relating to Information and Communication Technology, the fascinating subject that connects technology with the legal world. In this lesson, we'll explore how the law protects digital information, regulates online activities, combats cybercrime, and governs the technology we use every day. Whether you are a student, future IT professional, or simply a technology user, understanding ICT law is essential in today's digital society. Let's begin our journey into the legal side of the digital world. Under the local legislation, the first one is the Evidence Act. This is the first law of computer-related devices. If we want to prove something, there is a procedure. According to Section 4, considers contemporaneous recordings. This section says that audio recordings, video recordings, CCTV footage, phone recordings, and similar electronic recordings can be accepted as evidence in court if certain conditions are met. Contemporaneous means the recording was made at the same time the event happened or very close to it. Imagine a CCTV camera records a person stealing a laptop from shop. The CCTV footage can be used as evidence in court if the following conditions are satisfied. The first condition, made using electronic or mechanical devices. According to this condition, the recordings must have been made using equipment such as CCTV cameras, mobile phones, voice records, security cameras. For an example, a CCTV camera records a theft. The second condition must be capable of being seen or heard. The recording should be playable or viewable so that people can perceive it with their senses. For an example, the video can be played on a computer and clearly shows the incident. If the file is completely corrupted and cannot be opened, we can't present it in court. The third condition, the device must have worked properly. According to this condition, the recording device should have been functioning correctly. Even if there was a minor fault, the recording can still be admitted if the fault did not affect its accuracy. For an example, a CCTV camera's date stamp is incorrect, but the video itself is clear and accurate. If the camera frequently skips frames, the recording is unreliable. The fourth condition is no alteration or tampering. Sorry, the word should be tampering. According to this condition, the recording must not have been edited, modified, or manipulated after it was made. For an example, original CCTV footage is submitted directly from the system. If someone cuts out parts of the video or edits the audio before presenting it to court, you can't present it in court. The next part, section 4.3. Sometimes the original recording cannot be used directly in court. In such situations, the court may accept another version of the recording instead. This can happen if, first one, the recording cannot be played or displayed. It means the original recording cannot be opened or played because of technical problems. What are the examples? A CCTV video is stored on an VHS tape, but no VHS player is available. The next example, a damaged CD cannot be read. The next point is the recording can be played, but it is unintelligible. It means the recording exists, but people cannot understand it. What are the examples? An audio recording is full of background noise. A video has no clear sound. The speaker uses a language that the court does not understand. This is the last point. It is inconvenient to use the original recording. It means the original recording is too difficult or impractical to present in court. What are the examples? A 10-hour CCTV recording when only 5 minutes are retrievable. Are relevant. And next one, a huge database containing only one important record. The next one, a recording is stored in a complex technical format. What can the court do? Instead of using the original recording, the court may accept transcripts. Transcripts mean a written version of spoken words. And translation. Translation means the recording translated into another language. The next one, conversion. Conversion means changing the recording into another readable format. And next one, transformation or duplicate. It means a copied or converted version of the original. This can be done using appropriate equipment or devices, example software or machine, or human assistance, example translator or transcription expert. What are the examples? The first one, a CCTV recording is stored in an old format that today's computers cannot play. The second one, a forensic expert converts it into an MP4 video. The third one, the court may accept the converted MP4 version instead of the original type. Sorry, not type. It should be tape, right? Original tape. The next one, section 5.1. Compute evidence. This section says that information produced by a computer can be accepted as evidence in court if three conditions are satisfied. For an example, suppose a bank prints your transaction history from its computer. The printout can be used as evidence in court. The first condition is the information can be seen or read. Seen or read. This means the computer output must be capable of being perceived by the sensors. What are the examples? A printed bank statement, a PDF invoice, an email displayed on a screen. We can't get a corrupted file that cannot be opened as an example. The second condition is the computer was working properly. It means the computer should have been functioning correctly. Even if there was a minor fault, it is still acceptable if the fault did not affect the statement or its accuracy. For an example, the printer was low on ink, but the data stored in the computer was correct. The last condition is the information entered into the computer was accurate. It means the data entered into the computer must be correct. For an example, a cashier correctly enters a customer's payment into the system. If someone enters the wrong payment amount and the computer simply prints that incorrect information. Remember, a computer only processes the data it receives and remember this, if incorrect data is entered, the computer will produce incorrect results. The next one, section 7, access and inspection. If one party wants to use computer evidence in court, they must allow the other party to examine that evidence before the trial or within a reasonable time. This helps make the trial fair, so the other party can check whether the evidence is genuine and accurate. The party presenting the computer evidence must allow the other party to inspect the evidence itself, the computer, the machine or device, the records, the computer system. They must give the other party a reasonable opportunity to inspect everything. If the party does not allow access or inspection, the court will not accept their computer evidence. In simple words, no inspection is equal to no computer evidence. Example 1. A company wants to use CCTV footage to prove an employee stole money. Before the trial, the company lets the employee's lawyer view the CCTV footage, inspect the CCTV system, check that footage has not been altered. The court may accept the CCTV footage as evidence. Example 2. A company refuses to let the employee's lawyer inspect the CCTV footage or the computer where it is stored. The court may reject the CCTV evidence. The next one, section 12, interpretation. Section 12 explains the meaning of important words used in the Evidence Act. These definitions help court understand exactly what the Act means. First word is computer. What is the legal meaning of computer? A computer is any device that can store and process information. What is the simple meaning of a computer? A computer is any electronic device that stores data and works with it. What are the examples? Desktops, laptops, smartphones, ATM machines, banking systems, servers. The next word is duplicate. What is the meaning? What is the legal meaning of duplicate? A duplicate is an exact copy of the original made by photography, electronic, mechanical, chemical, or other methods. What is the simple meaning of duplicate? A duplicate is an accurate copy of the original document or recording. The next word is original. What is the legal meaning of original? An original includes the original recording or computer statement itself, as well as transcripts, translations, conversions, transformations, or duplicates that are intended to have the same legal effect. What is the simple meaning of original? The original is the main evidence, and in some situations the law also treats an officially prepared copy or converted version as having the same effect. What are the examples? Original CCTV footage, original voice recordings, original computer printouts, a certified transcripts of an audio recording, an official translation of a document. The next word is statement. What is the legal meaning of statement? A statement includes any representation of fact, whether made in words or otherwise. What is the simple meaning of the statement? A statement is any information or fact that is communicated not only through spoken or written words. What are the examples? A written report, an email, a text message, a computer-generated receipt, a graph or chart showing information. Let's discuss a case related to this act. Contempt inquiry in the Supreme Court 2009. In a Supreme Court appeal concerning photographic evidence adduced during a contempt inquiry, the court addressed the Act's application. The court evaluated whether the notice contemplated by Section 7(1)(a) of the Evidence Act had been given, highlighting the importance of procedure in admitting contemporaneous recordings. The next main act, Penal Code Act number 16 of 2006. Let's discuss Section 2(1) acts committed within Sri Lanka. First one. Before learning law applies, what is the main goal of this? Main idea, right? This section explains where Sri Lankan law applies, even if an offense happens outside the country's land. Sri Lankan law may still apply in certain places. Sri Lankan law applies if the offense is committed. Omissions and commissions are included in this act. The omission means things that should not be done. The commission is the opposite of omissions. The first condition is wholly or partly within Sri Lanka. According to this, The offense happens completely or partly in Sri Lanka. What are the examples? A person hacks a computer while in Colombo. A fraud starts in Sri Lanka and ends in another country. The second point is within Sri Lanka's territorial waters or airspace. According to this, the offense happens in Sri Lanka's sea or airspace. What are the examples? First one, a crime is committed on a boat in Sri Lankan waters. Second one, a person commits an offense on an aircraft flying over Sri Lanka. The next point, on a Sri Lankan registered ship or aircraft. According to this, the offense happens on a ship or aircraft registered in Sri Lanka, no matter where it is in the world. For an example, a theft occurs on Sri Lankan Airlines aircraft while flying over another country. The next point, at the Sri Lankan embassy or diplomatic residence abroad. According to this, the offense happens inside a Sri Lankan embassy or the official residence of a Sri Lankan diplomat in another country. For an example, a crime is committed inside the Sri Lankan embassy in India. The next point, at Sri Lankan government premises abroad. According to this, the offense happens at a building outside Sri Lanka that belongs to or is controlled by the Sri Lankan government or Sri Lankan statutory body. For an example, a crime is committed in a Sri Lankan government office located in another country. The next one, Section 2.2, acts committed outside Sri Lanka. What's the main idea of this? According to this, a Sri Lankan citizen cannot escape punishment by committing a crime in another country. If a Sri Lankan national commits an offense outside Sri Lanka that is against the penal code, they can still be punished under Sri Lankan law. For an example, a Sri Lankan citizen commits computer hacking while living in another country. Even though the offense happened outside Sri Lanka, the person can still be punished under the Sri Lankan Penal Code. That brings us to the end of today's lesson. In this video, we explored two of the most important laws in information and communication technology, the Evidence Act and the Penal Code, and how they apply in the digital world. But this is just the beginning. ICT law covers many other important areas that every student and IT professional should understand. In the next video, we'll continue our journey by exploring another important ICT law in simple, practical, and exam-focused detail. So, make sure you don't miss it. If you found this lesson helpful, please like the video, share it with your friends, and subscribe to the channel for more easy to understand ICT lessons. Thank you for watching, and I'll see you in the next video. Happy learning!